Okay, today's lesson is on the criminal justice system, criminal justice process in Texas. And I want to start with just a very general and quick overview of the crimes that are punished in Texas, the levels of crimes. So you've probably all heard of misdemeanors and felonies and so forth. So they range from the bottom Class C fines, Class C misdemeanors, which are punishable by a fine only. And then you get a Class B misdemeanor, which could be a fine plus jail. And then they go up to severity all the way to the top, which is life in prison for a capital offense. And kind of in the middle, you have a state jail felony, which can be punished with prison as well. I'll go into each one just a little bit more depth. So a capital felony is punishable by either the death penalty or life without parole. These are some examples. I do not expect you to memorize them by any stretch, but there probably will be 3 or 4 questions where I just give you like a burglary. Would that probably be a misdemeanor or a felony or something, vague, like something like that. And you can use the slides to look up the answer if you don't remember. So a capital felony, these are some examples. Killing someone who is known to be a police officer or fireman while they're on duty, murder for hire, killing someone while trying to escape from jail, killing jail inmates, committing mass murders or serial killers, engaging in serial killings, killing a child, someone under 15 years old, murdering a judge. Those would all be capital felonies. Those would all be eligible for the death penalty or life without parole. So first degree felonies, this is the level just below a death penalty offense, a capital offense. Punishable by 5 to 99 years and a possible fine. Aggravated assault, aggravated kidnapping, aggravated robbery, sexual assault, attempted capital murder. These would all be first degree felonies. Second degree felonies, aggravated assault, arson, bigamy, bribery, evading arrest, and which causes the death of someone else. These would all be second degree felonies. Bail jumping is when you are
auto bond and don't.
There you go. Yeah, you got it. So you've paid bail or somebody's paid bail for you, but you don't show up for trial, right? You try to flee. So that's bail jumping. So yeah, so like I said, third degree felonies, 2 to 10 years in prison, up to a $10,000 fine. Notice DWI, third offense. The first and second offense would be misdemeanors, punishable by jail, but third offense is now a felony. State jail felonies, burglary of a building, coercing a minor to join a gang by threatening violence, credit card abuse, cruelty to animals, DWI with a child passenger. These would all be state jail felonies. Now we get into the misdemeanors. Assault with bodily injury is a misdemeanor, up to a year in county jail, up to a $4,000 fine. A second offense DWI is a Class A misdemeanor. Burglary of a coin-operated machine would be a Class A misdemeanor. So there are several examples there. Class B misdemeanors, a DWI, so this would be the first one, would be up to 180 days in jail and up to a $2,000 fine. False report to a police officer, fraudulent, that must be cut off. I don't know what fraudulent degree is supposed to mean. Harassment, indecent exposure, prostitution, etc. And Class C, so this is the lowest level. No jail time, just a fine, up to $500. Assault by threat. What does assault by threat mean? Threaten somebody, right. You don't actually hit them, but the threat is a misdemeanor, right? And so that's a crime, up to $500 penalty. Gambling, issuance of a bad check, leaving a child in a vehicle, these would all be
How does
classified.
that work though, the threat? Like,
Say what?
How does the threat work? Like, these are gonna take.
Well, if there's a witness,
It gotta be a witness, huh?
well, I mean, there has to be evidence, right? So a witness would be the most logical evidence, but,
More that, more that come up, like social media.
well, it could be social media or it could be in person, right? If someone says, I'm gonna kill you, then that could be interpreted as a real threat, and that could be an assault, and that could be, that could be a misdemeanor. Whether it's in person or online, right? Either one could be a threat. Okay, so that's just a quick overview of the crimes. So now I want to give you a very quick, simplified process of what happens if a crime has been committed, the process leading up to the arrest, or what that process might look like. I got this information from the Fannin County Criminal District Attorney's Office, which is located here in North Texas near Oklahoma. So there might be tiny variations, but mostly this is going to be the case for state police offices, state county prosecutions all across Texas. So when a crime is committed, first step, law enforcement is notified. There's an investigation by the police, the sheriff, maybe the state police. There are some types of crimes that are investigated by agencies other than the police, like non-support, not paying child support. That might be invested by the state attorney general's office, I think. Public health related crimes. So if I run a business and I'm not following the health code, then there are other state agencies that would investigate that kind of a crime. So step 2, law enforcement investigates the crime. They interview witnesses, victims. They visit the crime scene. They collect evidence. And they generate a police report. So step 3, they might make an arrest, or they might file an at-large report with the district attorney. Now, of course, if a crime is committed in a police officer's presence, they can just make the arrest right then and there. But sometimes there's a crime committed and then they are aware of it after the fact, and so they have to go through this process of investigation. So, 4, the police report is reviewed by a prosecutor, and the prosecutor determines whether or not somebody should be charged with a crime. And if so, what the crime is they should be charged with. Sometimes they will send the report back or the case back to law enforcement and say, we need more evidence, we need more investigation. There's not enough here yet to charge somebody with a crime. Step 5, an information or indictment is issued. So this is the case where, this is the point where the prosecutor has looked at the police report and the prosecutor has decided, yes, this person committed a crime and let's officially charge them. If it's a misdemeanor, they charge this person, they use an information to charge someone with a misdemeanor. And that allows the county court to have jurisdiction of the case, and the trial is going to be most likely in a county court of law. If the prosecutor thinks that a misdemeanor has committed and there's enough evidence to convince a jury that the person is guilty, or convince a court that the person is guilty, they can issue the information just with a sworn complaint. So it's an affidavit. It says, I believe there's probable cause that person X committed this misdemeanor, and that's how they're formally charged with the crime. Now, if it's a felony that we're talking about, then we use what's called an indictment. And the indictment can't just come from the prosecutor by himself or by herself signing an affidavit. The indictment has to go through the grand jury. I mentioned grand juries the other day. So the prosecutor presents the information, the police report, whatever other evidence there is to the grand jury. The grand jury meets in secret. The defendant might not even know that the grand jury is meeting. They have no legal right to know. They have no constitutional right to know. And the prosecutor has to convince 9 out of the 12 people on the grand jury that there's probable cause that a felony was committed. If the grand jury agrees, they return what's called a true bill. And that means they can indict the suspect for the felony crime. If the grand jury is not persuaded, if the prosecutor can't persuade 9 out of the 12 jurors, then you get a no bill. And that means the person is not going to be indicted, not going to be charged with a crime. Now, if the grand jury no bills the indictment, the prosecutor can go back for more evidence. The prosecutor can tell the police, go do more research, try to find more information. We'll see if we can convince the grand jury later down the road. So, I think I said this already, but just to be clear, so an information goes to a county court for misdemeanors. A indictment goes from the grand jury to a district court, usually, for felonies. So then, if the person hasn't already been arrested and is sitting in jail, which is possible, or is out on bail, which is possible, a warrant is issued by a court, a county court or a district court, a warrant for the arrest who has been charged with the crime, either by information or indictment. Just to give you a simple, very simplified run through of all this, and then the suspect is arrested if they haven't been already. I knew someone about 5-6 years ago who was arrested for DWI. Now, the DWI was a first-time offense. So that means she was charged with, anyone remember what, a misdemeanor or a felony?
Misdemeanor.
There you go. A, B, or C? B, very good, yeah. So she was charged with a Class B misdemeanor. Now, the way it worked, she was arrested driving at night on the suspicion that she was drunk. So she was arrested, she was taken to jail, she was released on bail early the next morning, right, like 4 or 5 a.m. So the arrest and the bail and the release have already taken place months before she's actually charged officially with the misdemeanor. Does that make sense? The police arrest her, he sends her to jail, she spends the night in jail, she gets out the next morning on bail, and the police officer writes up a report about why he arrested her. Months down the road, a district attorney for the city or the county looks over the arrest report, says, okay, I think there's probable cause that she was guilty. He charges her with an information, not an indictment, because it's a misdemeanor, and now she is officially charged with the crime that she was originally arrested for. And it turned out, in this particular case that I'm aware of, the charges were dropped. They got back the blood work from Austin, which took months and months to get back, and it showed that she didn't have any drugs or any alcohol or anything in her system. So the whole case ended up being dismissed. Okay. Now, we're at the point of the arrest. So once arrested, officers must inform the accused person that she has the right to remain silent. But if she speaks, the statements she makes can be used against her. She has the right to consult with an attorney or have an attorney appointed if she can't pay for one. And she has the right to have an attorney present during questioning. With regards to this, what defense attorneys will always tell you is never talk to the police officers without your attorney. That there's no good that can come of it. Right? And you have the right not to talk to them without having your attorney with you. Within 48 hours of an arrest, the accused must be taken before a judge. The judge must inform the accused of the charges against her and and whether there is an affidavit supporting the charges. And the judge must also, this is going to be the second time probably, advise the accused of her right to retain counsel, remain silent, have an attorney present during any interview, terminate the interview at any time. She also has the right to conduct an examining trial, which is a hearing to establish reasons for her arrest or probable cause. The judge is also required to give her reasonable time and opportunity to consult with her attorney and set a reasonable bond if allowed by law. If the accused cannot post the bond and remains in jail, then the prosecutor must file charges against her by information, indictment, whatever, within 15 days for a Class B misdemeanor, 30 days for a Class A misdemeanor, or 90 days for a felony. So without that, she has to be released on a personal recognizance bond. So in the example I gave y'all, the person I know was arrested at 2 a.m. and released at 6 a.m. Suppose she had not been able to pay the bond, or no one was available to pay it for her. They would have had to charge her with the Class B misdemeanor within 15 days, or just let her go. Not meaning that they can now never charge her again. They just can't keep her in jail for months and months and months waiting for a charge to come, right? She has to be released in the meantime. There is a statute of limitations. If the accused is not in jail, then generally the prosecutor has up to 2 years from the date of the offense to file misdemeanor charges. Otherwise, the case is dismissed and can never be prosecuted. In a felony case, depending on the specific offense, the prosecutor may have up to 5, 7, or 10 years to file charges. For some serious charges like murder, sexual assault, and indecency with a child, the prosecutor does not have any time limitation to file charges. In this case, it was a misdemeanor. The misdemeanor occurred on December 31, if I remember correctly, of 2016. So on that day in 2018, it was now too late, and they could never bring charges against her again, even if they wanted to, not for that offense. An arraignment is the next step. So once the charge has been filed, the accused must make an initial appearance or arraignment where the court will give her a copy of the charging instrument. This is the information or the indictment, and she will have an opportunity to have the charges read in court, enter a plea, and request a continuance. Enter a plea means at this point the information is read, the charges are read to her, and she is asked, how do you plead? And she can say guilty, not guilty, no contest. Or she can request a continuance, and this is very common. She might say, I need time to find a lawyer, can I have a continuance? And the judge will say yes, we'll meet a week later or a month later. Now, most cases are continued or reset for announcement settings to allow for further investigation by the defense, the prosecutor, or both. At the arraignment, the prosecutor will usually allow the defense attorney access to the state's file, including the police report. They will convey an offer or enter into plea negotiations, and they will entertain requests for access and copying of evidence, such as videos, 911 calls, and confessions. The defendant has the following rights throughout the process. First, the presumption of innocence until proven guilty. Second, the prosecutor has the burden to prove the defendant's guilt beyond a reasonable doubt. Third, the right against self-incrimination, so the defendant cannot be forced to testify if she doesn't want to. Fourth, the right to a speedy trial by an impartial jury. Fifth, the right to confront or cross-examine the state's witnesses. 6, the right to subpoena witnesses to testify for her, and 7, the right to appeal. Now, what I mean by all that, suppose it goes to trial and the police officer who arrested you doesn't show up for the trial. What's likely to happen? Very likely, yeah. You might get the case dismissed because the only witness against you presumably never showed up. It might be continued. The state would most likely ask for a delay and the judge might grant it to try to find out where the police officer is and get them there. But you're not going to be convicted without the chance, you shouldn't be, without an opportunity to confront the witness. So, before the trial, there are several procedures and hearings that can occur. Most of these, such as bond reduction hearings and motions to suppress evidence, are actions that lead up to a trial, and they are very important to the progress of the case. First, we have bail hearings or bond hearings. At a bail hearing, the judge may place certain conditions on the accused to make sure that she will return to court if released from custody. All individuals, except those charged with a capital murder, have the right to be released on bail if they can provide sufficient collateral. And the bail is set with the court's discretion on a case-by-case basis. If the bail is too high, a defense attorney can request a bail reduction hearing. At the hearing, the defense attorney needs to show that the accused does not have enough collateral to pay such a high bond, is not a flight risk, has ties to the community, and is not a danger to the public or the alleged victim. There are instances in which a judge can deny bail, and if bail is denied, a defendant is entitled to a hearing within 48 hours of her arrest. So, to be released on bail, a bond must be posted, and there are 3 kinds. A cash bond is when the defendant pays the full amount of the bond in cash to the sheriff. The money will be refunded once the case is over. So I'll give you back to my DWI example. In this case, it was set at $5,000. So in order to pay a cash bond, the arrestee, the person who was arrested, would have had to pay $5,000 in cash that morning. How many of you have $5,000 in cash? Don't raise your hand. I don't, and most people don't. So a cash bond might be possible for some people, but more likely is number 2, a bail bond, and that's what happened in this case. This is when a defendant uses a bonding company or a bail bondsman to borrow the collateral. The bondsman will charge a fee and may require additional conditions on the defendant, and the fee will not be refunded once the case is over. So in this case, because the defendant did not have $5,000 in cash available at 6 a.m. in the morning to pay for the bail, she had to go to a bail bond company, pay them $500, and then they paid the $5,000 to the county. Does that make sense? If she shows up for trial like she's supposed to, or the case is dismissed, they get their $5,000 back, right? Does she get her $500 back?
Yeah.
It's gone, right? That was the fee she paid them to get her out of jail. That's how they earn their business, and that's why if you don't show up for jail, in this case, she had to call them every week, once a week, to prove that she was still in town, right? Because if she's not, if she stops calling them, or if a trial date comes around and she's not there, that's where you see the stuff on TV. They hire a bounty hunter to go find her and bring her back.
Revoke that bond?
Yes.
They warrant that for you.
Well, the bond is revoked, and that means the money is forfeited, right?
Yeah. You got a warrant.
Yeah, and there's a warrant for your arrest. That's exactly right. Now, number 3 is a personal recognizance bond, and this does happen. This is when the court uses its discretion to release the defendant without requiring a surety or other collateral. In felony cases, serious felony cases like murder, you're not gonna see a personal recognizance bond. But in a minor misdemeanor, you might. This is where the judge just says, okay, you're released, you don't have to pay anything, just show up for trial.
They can get them out when they know they're gonna get charged most of the time.
How do you mean?
Like, they get them, PR bonds when they know the person in question is gonna get charged. Like, when they let them go, they know when they go to trial, like, they damn near gonna get charged.
Huh, maybe so.
It just be like, they plead their case well to get out, and then the judge show them sympathy. It just depends on who the judge gonna be.
Yeah, it definitely depends on how the judge is, absolutely, absolutely. Yeah. Okay, so now I wanna talk about a motion to suppress. A motion to suppress happens before trial, and it's a way to keep out evidence that was obtained in violation of defendant's legal rights. So the motion to suppress is going to argue that the police seized evidence maybe without a proper warrant, or they forced a confession from the defendant. In a DWI prosecution, like the one I was talking about, a defense attorney may file a motion to suppress if the police did not have reasonable suspicion to pull the defendant's vehicle over. So the court grants a hearing on the motion to suppress, and it might hear testimony, it might see affidavits, and it decides whether or not the motion should be granted or denied, and whether or not the evidence should be kept out of trial. So in the DWI case, if she goes to trial and she wants to file a motion to suppress, or her lawyers do, what they're going to argue is the police should have never pulled me over in the first place. Right? They had no right to do so, no justification for doing so. If they convince the judge that they had no justification for pulling her over in the first place, every bit of evidence obtained after that goes out the window. Right? But it's hard to convince the judge that in reality. If she confessed, she might want to try to argue that the confession was coerced. She might want to argue that the police officer forgot to read her rights. What if the police officer didn't read her Miranda rights? What if the police officer didn't tell her, you have the right to remain silent? I'm sorry?
She would be released. She would know. She would be able to stay silent.
Yes. Well, you're probably right, but you're jumping the gun just a little bit to say she would be released. The first step is the confession would be thrown out of court. And then without that, yeah, she probably would be released, right? But once it was determined that her rights were not read to her, probably anything she said would be inadmissible. And so basically all the evidence against her would just kind of go away. Plea negotiations. So here, the defendant's attorney will talk to the state's attorney, the district attorney, the prosecutor, and they will try to arrange a deal, a plea bargain. Now, her attorney must inform her client of all reasonable offers made by the state's attorney. Defense attorneys can get into big trouble if the state's attorney makes an offer and they don't relay that offer to their clients. A plea bargain may require the accused to plead guilty instead of no contest, and may require the waiver of certain rights. If a plea bargain is made and agreed to by both sides, the judge is not obligated to accept the deal. It is only a recommendation made to the judge. If the judge rejects the plea agreement, the defendant can withdraw the plea of guilty or of no contest. I'll give you an example. It has to do with the DWI, but it occurred in Florida. A few years ago, I read about a case where a woman who already had, I think, a couple of DWI arrests on her record was driving drunk and hit somebody and left him paralyzed for life. And the district attorney and her defense lawyer made a plea bargain agreement where she would not go to jail. She would just pay a fine and have like community supervision or something. And the judge rejected the deal. The judge said, no, you paralyze somebody for life, you have to go to trial. And if you're guilty, you have to go to jail. I'm not gonna accept an agreement where there's no jail time involved. So he threw it out. Now, most of the time, judges accept the agreement, but they don't have to if they really think it's a bad deal. So, here's an important thing. Approximately 98% of all criminal cases are resolved with some form of plea bargain. I know so much about this case because I went to the arraignment for the person who was arrested for DWI about 6 years ago. And in this case, they were all read the charges against them. There was a huge room full of people, like 100 people, all being arraigned, all being accused of the crime that morning at the same time. And it was just like clockwork, 1, 2, 3, 4, 5, all the way up to 100, however many it was. And then the district attorneys were all sitting at a table at the side, and almost everybody there, except us, went and made a plea bargain right then and there, and signed papers and agreed to a punishment, and it was all over. And that's how 98% of these cases are solved. In this case, we knew she was innocent, so there was no plea bargain necessary. Discovery. This is the process before a trial in which information about a case is exchanged between the prosecutor and the defendant. The accused may file a motion for discovery either before or during trial. And the accused may request to inspect and test evidence, gain access to audio, video, photographic, electronic evidence, examples of evidence that may be considered, any documents that the state has that are pertinent to the case, photographs, etc. The basic rule here is the defendant asks to see all of this, the prosecutor's evidence, and they are required to show her everything by law. And they were specifically required to show her anything they have that might exonerate her or prove her innocence. And if they don't do that, I'll show you cases, not in this class but in others, they can get in trouble, right? That's a big, big problem. In this case, there was a point where we thought that they might not drop the case and it might go to trial. So I helped this person file a motion for discovery, and what it said was, show us all your evidence. Show us any police reports you have. Show us any results from blood tests that you have, et cetera, et cetera, et cetera. Anything that you have to show it to us. And there was no trial, but if there had been, they would have had to show all those things before it could begin. The defendant is not entitled to written statements of witnesses and the work product of the prosecutor or the prosecutor's investigations. Both the defense and the state may request the other side to disclose the name and address of expert witnesses. Each side is entitled to take depositions of witnesses. And all of that takes place before the trial begins. So there are 3 phases of the trial. I guess there are 3 phases. First, there's jury selection, which is really before the trial begins, but close enough. So first you have jury selection, then you have the guilt-innocence phase of a trial, and then last you have the punishment phase. There are basically 2 kinds of trials. There's a jury trial, or there's trial by judge. There's a third option, which is slightly different. There's a plea of guilty with a pre-sentencing investigation. So a defendant may waive a jury trial at the guilt-innocence phase and plead guilty without any sort of plea bargain, and have a judge or jury assess punishment within the range of punishment. Now, for jury selection, you've probably seen this in movies and on TV. The process of selecting a jury is known as voir dire. During voir dire, a panel of people will be questioned by both sides about their background, beliefs, and biases, and then the jury will be selected from this larger panel. And the goal of this selection is to identify unqualified jurors, potentially biased jurors, and unfavorable jurors, and eliminate them from the pool of potential jurors. And what you want to result with, or what you want to conclude with, are 6 jurors for misdemeanor cases and 12 for felony cases. Each side has an unlimited number of challenges for cause. A challenge for cause is when one side believes that a prospective juror has a bias against them. For example, a prosecutor in a capital murder trial might challenge a prospective juror who says that she objects to the death penalty because of her religious beliefs. The defense attorney might challenge a prospective juror who says that he believes that any defendant who refuses to testify is guilty. These would be challenges for cause, and you have an unlimited number of those. Each side has a limited number of peremptory challenges. That means each side can simply strike a certain number of prospective jurors from consideration and does not have to explain why. The number of peremptory challenges depends on the type of trial. In a typical felony trial, it's 10 peremptory challenges per side. In a typical misdemeanor trial, it's 3 per side. So just to make that clear, suppose I'm the lawyer defending somebody in a misdemeanor trial, okay? And so what I do in voir dire is I talk to all the people on the panel. I ask them questions. And I might know in my head that my client is probably not gonna testify. She doesn't want to testify. And so I ask one of the jurors, do you think people who invoke their Fifth Amendment right not to testify are guilty? And he says, yeah, I think that means they're guilty. Well, that's a strike for cause. I can remove him from the jury because you have a Fifth Amendment right to not testify. If he doesn't agree with that, then he can't, as a juror, respect your constitutional rights. Suppose there's another person I'm talking to, and I ask them some questions about himself or herself, and I just have a feeling, a gut feeling, that he's not gonna like my defendant. And it's not something like he's biased, it's just an impression that I have. I have 3 peremptory strikes. I can remove him from the jury pool without explaining why. Up to 3 times. And then I'm just stuck with whoever I get. Right? There's one big exception to the rule for peremptory strikes, that I can strike someone without explaining why. And that is, no strike can be based on race. So the state may not strike an African American or Hispanic panelist because the defendant is the same race, or because the prosecutor believes that minorities are soft on crime. So suppose the prosecutor in the case, suppose I'm the prosecutor, and I decide I'm trying to prosecute a black suspect. And there's a black woman or a black man on the jury panel. Can I strike that person just because I suspect that he will have sympathy for a suspect of his own race? No, that's not a valid reason to make the strike. I can't do that. So when the defense attorney believes that the prosecutor has made an improper race-based strike, he will make a Batson challenge. A Batson challenge is named after the U.S. Supreme Court case that forbids race-based strikes. And this requires the prosecutor to show that his strike was not racially motivated. So in this hypothetical, the prosecutor strikes the black panelist or the Hispanic panelist or the Asian panelist, and the defense raises a Batson challenge, and the prosecutor now must explain why he struck the juror for some reason other than race, which is prohibited. Okay. Now we go to the guilt or innocence phase of the trial. The state will present evidence such as witnesses, lab reports, testimony. The defense attorney will have the opportunity to cross-examine the state's witnesses and present a case on the defendant's behalf, including calling defense witnesses to testify. You have opening statements at the start of the trial. The prosecutor will read the charging instrument to the jury. The prosecution then makes an opening statement, and the defense lawyer can respond with an opening statement of her own or postpone it until later in the trial. The opening statement should not contain arguments. It should only describe the facts and how the prosecutor and the defense lawyer believe the evidence will show those facts. After opening statements, the state will present its evidence through its witnesses. The defense will have an opportunity to cross-examine the state's witnesses. After the state finishes, the defense can elect to present its evidence. After the defense finishes its case, the state can then call rebuttal witnesses, and then the defense can call rebuttal witnesses. The types of evidence that can be presented: testimony, obviously, of witnesses, documents, writings. This could be police reports, diaries, letters, photographs, tape recordings, any other tangible or physical evidence. And then you can have demonstrative evidence like maps, charts, diagrams, things like that could also be evidence. For evidence to be admissible, it has to be four things. It has to be relevant, so it has to have a tendency to make a fact of consequence more or less probable than it would be without the evidence. It has to be material. So it has to be related to the issues being decided in the case. It has to be authentic. This is obvious. It can't be fake. And it has to be not privileged. Here, what I mean by this is certain information does not have to be disclosed or discussed by the opposing party and cannot be asked about in testimony. This could be a lawyer-client privilege. This could be spousal privilege. This could be doctor-patient privilege. It could be a conversation with a clergy member. So, a conversation between a defendant and her spouse might be privileged, and you can't call the other spouse to testify against his or her spouse who's a defendant. Once all the testimony is finished, the judge will prepare a jury charge. This contains the law and instructions to help the jury decide the verdict. The charge is prepared outside the presence of the jury and then read to the jury. The prosecutor and the defense will then make their closing arguments to the jury, and the jury is given a copy of the charge, and they decide the verdict in secrecy. If they cannot reach a unanimous verdict, the judge can declare a mistrial. A mistrial means that the trial concluded without a decision of guilt or innocence. A mistrial can also happen if one side violates certain rules of evidence. For example, I mentioned earlier, if the prosecution fails to hand over evidence that might exonerate the defendant as material to the case, that could result in a mistrial. Or if the prosecutor improperly brings up the criminal conviction in an unrelated case or an earlier case of the defendant, the judge could declare a mistrial. If a trial ends in a mistrial, usually the state can try the defendant again, but they have to start all over. If a defendant is found guilty, a punishment phase determines the sentence. In Texas, the judge is the default choice to decide the sentence, but a defendant has the right to have a jury decide the sentence instead. The punishment phase is similar to the guilt or innocent phase. Both sides make opening and closing statements. Both sides can put on witnesses. A big difference is that almost any information about the defendant can be considered in the punishment phase. These rules don't necessarily apply. The rules about relevant material, authentic, etc. Well, authentic probably still applies. So the state may prove up the defendant's prior criminal record, put on witnesses to testify about the defendant's character, or try to prove that the defendant committed other bad acts. The state can ask the judge or jury to consider much more information about the defendant, information that would not be allowed during a guilt or evidence stage of a trial. So if the defendant is convicted and sentenced, the defendants convicted of a crime generally have a right to appeal the conviction unless they've given that right up as part of a plea bargain or some other agreement with the state. The appeal process begins with the decision to file a motion for a new trial. These motions are usually not granted, but it's the first step in appealing the decision. Then, the second step is the filing of a notice of appeal. There are deadlines for filing the notice of appeal, and they are strictly enforced in criminal cases, and therefore, if someone is found guilty, they need to file the notice of appeal as soon as possible. The third step is the preparation and filing of the record on appeal. Unless a determination has been made that a defendant is indigent or poor, they are responsible for making arrangements to pay for the preparation of the record. And failure to do so may result in dismissal of the appeal. Preparation of the record means basically you have to go to the court reporter, to the court clerk, and you have to pay to have a transcript produced of the trial. And then that transcript is going to be sent to the appellate court, and they're going to use it to determine whether or not you are entitled to a new trial or a reversal of the verdict against you or whatever. The fourth step is the preparation and filing of the briefs on appeal. Briefs are to help the appellate court with the history, facts, and legal issues involved in the case. After the briefs have been filed, the appellate court begins deciding the case. If the appellate court decides against you, you can file for review with the Texas Court of Criminal Appeals, which is the highest criminal court in Texas, but reviews are rarely granted by that court, so it's not likely that you'll get much farther. So that's the process, from arrest to verdict to appeal. Now I want to shift a little bit and talk for a few minutes about incarceration in Texas and some recent evidence or efforts towards reform. So I found these statistics. Some of them are 12 years old, some of them are just 4 years old, so they're more up to date. This comes from 4 years ago, so it's probably still fairly up to date. But according to a group called prisonpolicy.org, in 2018 there were about 250,000 residents in Texas who were in jail or prison. That's including local jails, federal prisons, state prisons, and youth detention centers and involuntary confinement. So 250,000 Texans. How many people are involved in our prison system if you include probation? Well, it gets much, much bigger. And parole. So we had 163,000 people in state prisons. We had 55,000 people in state jails. This is in 2018. But we had 107,000 people out on parole and 368,000 on probation. So what does that bring it to? About 500,000 or so, or more. This is an interesting chart showing Texas's prison and jail incarceration rates. You can see that around 1991 or 2, Texas prison population surpassed the county jail population, and it's been that way ever since, right? The jail incarceration peaked around 1991 or so, and then it was jagged for a little while, and it seems to have hovered around 200,000 for the last 20 years or so. The prison incarceration rate peaked in the late 1990s and has been steadily declining ever since. But it's still greater than the county jail incarceration rate. The one thing I wanted you to see for this is about 10 years old, but I think it's still true from everything that I know. The people in jail who are in a pre-trial status, the number of those people is much higher than the number of people who are in jail because they've been convicted of a crime. What do I mean by that? That means most of the people who are sitting in jail now, today, have not been convicted of anything. They're waiting for their trial. Does that make sense? At least 3 out of 4 of them. And for some people, we don't have time to get into it too much, but that suggests a real problem. I talked about bail earlier, and I saw an example. I don't know where it was from, which part of Texas, but supposedly a woman who was a grandmother somewhere in Texas was arrested for shoplifting $100 worth of stuff, and she was sent to jail. And the bail was set at $150,000. So if she wanted to get out by paying the bond herself, she'd have to pay $150,000. Is it likely that she had $150,000 in cash? No, or she wouldn't have been shoplifting $100 at the grocery store. So she couldn't pay the bail. She couldn't even pay a bond company to pay it for her, because that still would have been about 10% of that. She would have had to pay them about $15,000. And then that money would have been gone forever, whether she won or lost, right? So financially, she has no alternative but to just sit in jail until she is either given a trial and convicted or acquitted, or the case is dismissed. And I don't know how many, but there are many cases of people who are sitting in jail because they can't or won't pay the bond. And so that's something that some reformers have suggested is a serious problem in Texas. Another issue, and this is very complicated and very controversial, is that some people think that there's a problem because Texas incarceration rates differ by race or ethnicity. So this is per 100,000 people in Texas. So 768 white people per 100,000 white people in Texas are in jail, versus 972 Hispanic people and 2,855 black people. So the number of black people in jail in Texas per capita is about 4 times as high as the number of white people, right? Looking at this chart. And this statistic is from 10, 12 years ago, but it's probably still basically accurate. Now, there are lots of groups who are dedicated to criminal justice reform. I saw these facts and figures on a site called Nolan Center for Justice. And you notice that the prison population has been going down for the last 15 or 20 years. I talked about that. So if you start it in 2000, and you look at the 5-year period going from 1995 to 2000, during that period, Texas built 38 prisons, 38 new prisons. And by 2007 was spending about $3 billion a year on prisons and parole. And the population, the prison population seemed to be just exploding and exploding. So about 2007, Texas implemented a series of reforms. And these reforms included reducing sentences for nonviolent offenders, mandating probation and drug rehabilitation as alternatives to incarceration for first-time, low-risk nonviolent offenders, giving more discretion to judges in sentencing nonviolent offenders to treatment programs, parole, and probation, reducing probation sentences for eligible successful probationers, and expanding drug and specialty courts. So the gist of all of that is trying to find alternatives to prison for people who are in trouble for drug offenses or people who are in trouble for other types of nonviolent offenses. And since enacting these reforms, Texas has saved over $2 billion and has reduced the size of its prison populations. Crime rates have dropped by 29%, giving Texas the lowest crime rate in its history since 1968. And in the last decade, Texas has closed 10 of its prisons because the prison population has been smaller and smaller, and there's been less and less need for them. And many people around the country have considered that an example of successful prison reform here in Texas. That's where I'll stop for today. I'll see you next time.